When police arrive at a DUI stop, the people around you are not protected by your Miranda rights. A passenger, a spouse, a friend who showed up at the scene, any of them can be questioned, and most answer out of nervousness or a genuine wish to help. What they say gets written into the police report, sometimes word for word, sometimes paraphrased. Once it is in that report, it is part of the record. The most common companion statements are things like, "He had a few drinks at dinner, she seemed a little off," or "We were at the bar for about 3 hours." These observations sound casual, but under Vehicle Code 23152A, which is the impairment-based DUI charge rather than a specific BAC number, a prosecutor can use them to argue you appeared impaired before you drove. Even well-meaning words can land in a charging document. A companion statement is one piece of evidence, not a verdict. Context matters. If the person told the officer you seemed fine, and the officer arrested you anyway, that tension in the record is something a defense attorney can use. If the statement contradicts the officer's own account, or if the officer paraphrased it inaccurately, that inconsistency matters too. No single statement defines a case. What defines it is how thoroughly every piece is examined. People often ask whether their friend or family member can simply say they were misquoted or that they made a mistake. A witness can clarify or expand on what they said, and they can provide a written declaration or testify with a fuller account. What they cannot do is fabricate a new version to benefit the defendant. Honest clarification is legitimate. Coordinated story changing is not, and it can create legal exposure for everyone involved. The same person who spoke to police is not automatically locked into the prosecution's side. If that friend or family member can credibly testify that you were not impaired, or that the officer mischaracterized what they said, your attorney can interview them, take a written statement, and decide whether calling them at a pretrial motion or at trial would help. This is also why early attorney involvement matters. That conversation should happen in a structured, protected way, not in an informal phone call before you have counsel. A California DUI arrest triggers two separate proceedings: the criminal court case and the DMV administrative hearing. The DMV hearing centers on whether the officer had reasonable cause to arrest you, whether a chemical test was lawfully requested, and what your BAC result was. A companion statement is less central there than in court, but if it appeared in the officer's sworn DS-367 report, it is in the DMV packet and should be accounted for in your hearing preparation. Whatever was said that night, the full picture matters more than any single line in a police report. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.